So the paper that I shared is about the interpretation of precedent in the interjurisdictional or conflicts of law context. So what does that mean? Well, courts often have to interpret and apply the law, including the precedent of foreign jurisdictions. So for example, a court in the US might have to decide a question of Canadian law. A Wisconsin court might have to decide a question of Colorado state law. In the US, state courts are often charged with deciding questions of federal law, and likewise, federal courts often have to decide questions arising under a state's law. And in the paper, I focus for illustrative purposes on this US federal state context. But my main analysis should translate, I think, in a pretty straightforward way to other contexts as well, wherever a court in one jurisdiction has to apply the law of another. And I focus on the interpretation of precedent or judicial decisions, but I think that my main conclusions also extend to other domains of legal interpretation, for example, statutory interpretation, and some of my examples do concern the interpretation of statutes. So this diagram is just meant to illustrate the basic scenario that I'm interested in. So here on the left of the slide, we have a federal court, the US Court of Appeals for the Seventh Circuit, and sometimes it will have to decide questions of Wisconsin state law. And in the process of doing that, it will have to interpret and apply judicial decisions issued by Wisconsin state courts. And then likewise, Wisconsin courts will often have to decide questions of federal law. So for example, the Wisconsin Supreme Court, which is featured also on the slide. And when Wisconsin courts interpret federal law, they'll have to apply federal judicial decisions. So a note on terminology for those who might not be so familiar with the conflicts of law literature. Suppose that the Court of Appeals for the Seventh Circuit, the federal court, here is charged with deciding a question of Wisconsin law. In that case, the federal court would be called the forum court because it's the forum where the adjudication is happening. I often call it the law applying court to be as explicit as possible. And then in that scenario, Wisconsin state courts would be the law supplying courts because they're the ones that issue the judicial decisions that the federal court would have to apply. We can also call the Wisconsin courts the home courts because the law being applied is at home there. Okay, so I take it for granted that a forum court, when deciding a question arising under another jurisdiction's law, ought to actually apply the law of that other jurisdiction, including where it exists, the precedent. So the forum court can't just make up the law to be applied or apply its own law. And I think that that's an uncontroversial claim. In the US context, at least, it's well established that when federal courts decide questions arising under a state's law, the federal courts have to actually apply the state's substantive law, including the state's judicial decisions. And likewise, when a state court answers a question of federal law, it has to apply federal substantive law. The question that I'm interested in, though, is whether the law applying court also has to apply the law supplying jurisdictions methods of interpreting precedent or methods of precedential interpretation. And by methods of interpreting precedent, I mean the techniques that judges use to ascertain the legal meaning that a past judicial decision has in the context of a new case that's up for decision. So there's a huge body of literature on interpretive methodology, and it focuses mainly on statutory and constitutional interpretation. And within this literature, there's an extensive debate about whether a law applying court ought to use the methods of statutory interpretation that courts in the law supplying jurisdiction would use. And that's an ongoing debate. In contrast, methods of interpreting precedent have received surprisingly little attention. So to the extent that legal scholars have said anything about the interpretation of precedent in the conflicts of law context, they've generally assumed without argument that methods of interpreting precedent travel with the underlying law. So that would mean that if a court is applying another jurisdiction's precedent, it also has to apply the other jurisdiction's methods of interpreting precedent. So I don't think that we should accept this assumption. And I'll try to show how our answer to the question of whether and when a law applying court has to apply the interpretive methods of the law supplying jurisdiction depends on what kind of theory of law we subscribe to. Okay, but before I turn to my main theoretical argument, I want to fill in some more background details. So do methods of interpreting precedent even differ? Because if they didn't, then my paper would really be a matter of theoretical interest only. Methods of interpreting precedent do differ, though, in various ways across judges, courts, and jurisdictions. And a context where these differences are particularly salient is in the interpretation of plurality decisions. So a plurality decision, also called a fractured decision, by definition, has no majority opinion or opinion of the court. So instead, we have a series of opinions, each of which was only endorsed by a minority of the judges deciding the case. So any multi-member court can issue a plurality decision. In some jurisdictions, plurality decisions aren't binding at all. Kentucky, the state of Kentucky is an example. But for other jurisdictions, they're binding in various ways. For example, some courts treat the concurrence that received the most votes of all concurrences as binding. This is called the plurality opinion. Some courts use what's known as the narrowest grounds rule to construe plurality decisions. And this approach would treat the opinion that concurred in the judgment on the most narrow basis or on the most narrow line of reasoning as binding. Other courts treat only majority endorsed principles from plurality decisions as binding. So a judge using this approach would look at all of the opinions issued as part of the plurality decision and see if there's any majority agreement at the level of rationale or principle to be found, and then the decision would be binding to the extent of that majority agreement only. So here's an example to make all of this a bit more concrete. So in a case called Kirby v. Illinois, the US Supreme Court issued a plurality decision. It's quite common for the US Supreme Court to issue plurality decisions. The question raised in that case was whether a criminal suspect who has been arrested and confronted with the crime victim for identification purposes, but not yet formally indicted, has a right to the assistance of counsel. And whether if the suspect was deprived of that right, then evidence from the identification event would have to be excluded from the trial. So the court concluded that evidence from the identification event in this case did not need to be excluded from the trial. And a majority of 5 justices agreed on that as the judgment or outcome of the case. But a majority could not agree on any ground or basis for that conclusion. And in particular, only a minority of the justices agreed that an individual does not have the right to assistance of counsel before indictment. So the majority of the justices were either silent on that issue or explicitly said that suspects do have the right to counsel before formal indictment. Okay, so following the court's decision in Kirby, multiple of the lower federal courts treated Kirby as standing for the proposition that criminal suspects don't have a right to counsel before indictment. So these courts faced with similar facts treated Kirby as a precedent for that principle. So they accordingly denied the right to counsel to criminal suspects who had been accused and detained, but not yet indicted. But from the point of view of some states, Kirby doesn't stand for that proposition. So for example, Michigan courts will take a principle from a judicial decision as binding if and only if a majority of the judges on the court agreed on it. So if there's merely a majority for a particular result, which was true of Kirby, then this is a quote that I'll read from a Michigan State case. Then the parties to the case are bound by the judgment, but the case is not authority beyond the immediate parties. So in keeping with this approach to precedent, the Michigan Supreme Court declined to follow Kirby as an authority on the right to counsel question because no majority in Kirby agreed on that issue. So this example is just meant to show how a case can have a different legal meaning from the point of view of some courts, in this case Michigan courts, than it does from the perspective of some other courts, in this case lower federal courts, purely because of a difference in interpretive approach. So is Michigan representative insofar as it uses its own methods of interpretation on foreign precedent? I haven't attempted any systematic or comprehensive empirical study of that question, and I don't think anyone else has either, but I did survey a few states and their federal court counterparts to try to get a sense of whether state courts tend to defer to federal methods of interpreting precedent and vice versa. And I found that courts often acknowledge and seem to genuinely recognize that they have a duty to apply the precedent of another jurisdiction without recognizing any corresponding duty to apply the methods of interpretation of the other jurisdiction, at least in the context of interpreting precedent. So instead, courts often proceed as though they're entitled and even obligated to apply their own interpretive methods, or just whatever methods they find to be the most appropriate or effective for ascertaining the rules of decision in the particular case. Okay, so what I'm most interested in then is whether there's a theoretical justification available for the separation that we see in practice, at least some of the time, between first order law and methods of interpreting that law. So this is the question that's really at the heart of my paper. So to be effective or successful at ascertaining the law, an interpretive method has to be connected to the contents of the law or to that which constitutes the law in the right way. So then the question becomes, will a jurisdiction's prevailing interpretive methods be connected to the contents of the law in the right way? So what I want to show is why we can't answer that question without making assumptions or commitments about the nature of law. And so our answer to the question of whether a law applying jurisdiction ought to defer to the interpretive methods of courts in the law supplying jurisdiction will depend on our theory of law. And I don't make any commitments to a particular theory of law in this paper. Instead, I look to a couple of different theories of law and see how the answer to the question I'm interested in would come out. And I find that under a positivist theory, and in particular, I take H.L.A. Hart's version of positivism as my example, methods of interpretation will generally travel with the underlying law, although not always or necessarily. Under alternative theories of law, and in particular Dworkin's notion of law as integrity, methods of interpretation won't as readily travel with the underlying law. And under both of these theories, law applying judges will sometimes be not only legally permitted, but actually required to reject the interpretive methods of courts in the law supplying jurisdiction. So I'll now spend a few minutes discussing positivism, and then I'll turn to law as integrity, and then I'll wrap up. So if you believe with Hart that a valid legal rule in a given jurisdiction is one that meets the conditions of the jurisdiction's rule of recognition, then a judge applying a foreign jurisdiction's law will be bound by the interpretive norms that the foreign jurisdiction's judges accept. And this is because for positivists, law is at bottom a product of the social rules that a jurisdiction's legal officials in fact practice and accept. So a court interpreting another jurisdiction's law has to follow the other jurisdiction's interpretive methods to the extent that those methods constitute social or conventional rules in the law supplying jurisdiction. And in some jurisdictions, legal officials, the relevant ones here are judges, of course, have converged on particular methods of interpreting precedent. And sometimes they've converged on those methods, not just as a matter of practice or habit, but also as a matter of felt obligation to a shared practice. So these methods then supply criteria for evaluating the legal validity of propositions contained in judicial decisions. And so the methods form part, I think, of the jurisdiction's rule of recognition. And Michigan's majority agreement approach to plurality decisions is an example of a method of interpretation that forms part of the jurisdiction's rule of recognition. And we saw how that plays out in Michigan's interpretation of the federal case of Kirby. So in contrast to Michigan, Kentucky judges, for example, don't follow a rule that would require them to treat majority endorsed principles from plurality decisions as binding. In fact, in Kentucky, plurality decisions aren't binding at all. So to this extent, the two states have different tests of legal validity. So let's turn to an outside court, a federal court, adjudicating a claim arising under state law. So if the federal court is dealing with Michigan law, then it ought to apply Michigan's approach to interpreting plurality decisions, the majority agreement approach. So this is because that approach amounts to a test of legal validity for the jurisdiction of Michigan. So if the federal court wants to get Michigan's first order law right, it can't ignore Michigan's tests of legal validity. But what if the federal court is deciding a Kentucky case and the relevant judicial decision is a plurality one? So Kentucky's rule of recognition doesn't seem to require judges to find legally valid rules in plurality decisions at all. As long as Kentucky's rule of recognition doesn't provide that plurality decisions can't serve as precedent, then the rule would seem to leave federal judges with discretion over the construction of plurality decisions. So this would be an example of a case where the applicable law is indeterminate. It just doesn't supply a singularly correct answer to the legal question that the dispute raises. And so the federal judge would be neither legally required to apply the Kentucky plurality decision, nor required not to. So Kentucky law would leave the federal judge with discretion over the matter. But there's a wrinkle to the story here, because the federal rule of recognition might require federal judges to apply a particular method of interpretation in the event of a gap in the state's law. And federal cases do suggest that federal courts deciding questions of state law do not necessarily have discretion wherever their state counterparts would. So in the event of unsettled state law, federal courts, I think, interestingly, generally take themselves as legally obligated to apply their own best prediction of how the state's courts would decide the case if they were the ones deciding it, or their best prediction of how the state's courts will in fact decide similar cases in the future. So this prediction doctrine then is part of the federal rule of recognition in the context of adjudicating state disputes. It's not part of the state's rule of recognition. So state courts, of course, don't take themselves as bound by their own best prediction of how they themselves would decide a given case. That wouldn't make much sense. So this is an example of how, under positivism, interpretive methods between the law supplying jurisdiction and the law applying jurisdiction can come apart. Okay, so to sum up this part of the discussion of positivism, under a positivist theory, a court seeking to identify the legal rules of a foreign jurisdiction should inquire into the actual behavior and attitudes of the foreign jurisdiction's judges. And to the extent that those judges have converged on some interpretive norms, then the law applying court ought to follow those norms as well. That's assuming that the law applying court wishes to correctly ascertain the foreign jurisdiction's law or rules of conduct. Okay, so I'm going to turn now to law as integrity. So if you believe with Dworkin that a judge's role involves deciding cases according to the principles that best fit and justify the law supplying jurisdiction's entire body of legal practices, then a judge will have no general duty to follow the interpretive methods of the law supplying judges. And this is because I think those methods might prevent the judge from performing the feat of fit and justification that law as integrity demands. So it's possible that the judges of some jurisdiction, for example, the state of Wisconsin, employ interpretive methods that generate principles and propositions that don't necessarily, or on every occasion, provide the best constructive interpretation of Wisconsin's legal practices. So then external judges tasked with applying Wisconsin law in a particular case might have no obligation to follow Wisconsin's methods of interpretation, and might even have an obligation from the point of view of law's integrity not to follow Wisconsin's interpretive methodology. The situation is more complicated, though, than I've made it seem so far, because Wisconsin's interpretive methods themselves are part of the jurisdiction's legal practices. So a good Dorkanian judge would have to take them into account in her effort to decide a case in accord with the principles that best fit and justify the entirety of Wisconsin's legal practices. So depending on the method of interpretation that a Wisconsin court would use in a particular case, the federal court may or may not have a legal duty to follow it. It depends on the content of the interpretive method and also the relationship between that method and all of Wisconsin's other legal practices. So I think that often it will be the case under law's integrity that a law applying judge shouldn't use the methods of interpretation of the law supplying jurisdiction. So I'll briefly describe a couple of example situations where I think that that's true. So where, from the point of view of law's integrity, a law applying court would not be bound by the law supplying jurisdiction's interpretive methods. Okay, so one of the most popular methods for interpreting plurality decisions in the US is the narrowest grounds rule, which I've mentioned already. And this rule provides that the opinion that supports the judgment most narrowly or on the most narrow basis is binding. So for example, in a case called Freeman versus United States, the US Supreme Court fractured into 3 factions. It was a 4-1-4 decision. So four of the justices agreed on one opinion, that was the plurality opinion, and then we have one in the middle writing a concurrence, and then 4 in the dissent. And Justice Sotomayor was the one who wrote the concurrence of 1, so just for herself. And this, her line of reasoning in support of the judgment was arguably the narrowest one and has been taken by other courts to be the narrowest argument in favor of the judgment. Okay, so most of the lower federal courts then, in an attempt to follow Freeman in cases that arose with similar facts, applied the narrowest grounds rule to Freeman and accordingly treated Justice Sotomayor's opinion, her solo concurrence, as legally controlling. But the narrowest grounds rule is inconsistent with the majoritarian principle that underlies the general federal doctrine of precedent. So in normal cases, it's majority opinions and only those that are binding. And the rule doesn't seem readily justifiable under other principles that underlie federal legal practices either. And in fact, the narrowest grounds rule has gotten a lot of criticism by both scholars and judges. Moreover, because no other justices agreed with Sotomayor's opinion, it's unlikely that her reasoning in fact represents the principles that best justify the outcome of the case. So for those reasons, I think that a state judge charged with deciding a question of federal law might do better by law's integrity to reject the narrowest grounds rule, at least if they're interpreting the case of Freeman. So here's one other example of a situation where under law's integrity, a law applying court might have a duty not to use the interpretive methods or approach of the law supplying jurisdiction. So some jurisdictions declare and treat certain subsets of judicial decisions as non-precedential. An example in the US is that federal intermediate appellate courts designate a large proportion of their opinions as not for publication and then treat them as non-binding. So a good Dworkinian judge might disregard that directive and recognize the force that all of a jurisdiction's previous judicial decisions have over subsequent cases. So Dworkin claims that the main purpose of precedent is fairness, and if that's right, then it would seem that judges ought to afford precedential weight to all of a jurisdiction's judicial decisions, regardless of the labels attached to them, because after all, they all represent legal practices in the jurisdiction, and they all had real consequences for the litigants involved in the cases. Okay, so in the examples I've given so far, law applying courts have conceptual reason to reject the interpretive methods of the law supplying jurisdiction. But there are also epistemic reasons why, under law's integrity, a court should sometimes maybe refrain from applying the foreign jurisdiction's interpretive methods. So I'll just give one quick example of this. So some jurisdictions embrace demanding methods of interpretation in some contexts, which are sometimes called creative methods of interpretation. For example, constitutional avoidance. And in the approach of constitutional avoidance, a court interprets a statute that would seem to present constitutional problems as if it were consistent with the Constitution. And it's sometimes seen as a meddlesome kind of interpretive method. So it might not be feasible for an outsider court to employ a method like constitutional avoidance successfully if we measure success according to Dworkin's theory of law. And this is because insider courts will just be more familiar with related statutes and precedents, and so probably more capable of coming up with a creative interpretation of the legal source at issue that provides a good fit with all the rest of these legal sources and legal practices. So in other words, outsider judges relative to insider ones might have epistemic disadvantages with respect to interpreting the applicable law, and those disadvantages might sometimes necessitate a difference in interpretive approach under law's integrity. And I think we can come up with other examples where this might be true. Okay, so to sum up the discussion of law's integrity then, a court deciding a question of foreign law shouldn't necessarily follow all of the interpretive norms of the foreign jurisdictions courts, because these norms, whether for conceptual or epistemic reasons, might undermine or obstruct the court's ability to produce the best constructive interpretation of the foreign body of law. Okay, so I will wrap up with some concluding thoughts. I've argued that we can't answer the question of whether and when a law applying court has to defer to a law supplying jurisdiction's methods of interpretation without grappling with fundamental and unsettled questions about the nature of law. And I don't try to resolve those fundamental questions, but I do show how two major rival theories of law generate different answers to the question of interjurisdictional interpretive deference. And although these theories generate different answers to that question, both of them suggest that a law applying court won't necessarily or always be bound by the interpretive practices of judges in the law supplying jurisdiction. Both theories provide, each for different reasons, that a judge can have a legal duty to apply another jurisdiction's law without having a duty to apply that other jurisdiction's methods of interpretation. But the types of interpretive practices that will travel with the underlying law under each theory differ. So I think that many of the examples we see in the US context, at least of judges not deferring to the interpretive methods of courts in the law supplying jurisdiction, can be justified under law's integrity, but not under positivism. So my analysis suggests that judges in the US are more Dworkinian than positivist, at least in their approach to interpreting the precedent of other jurisdictions. On the other hand, the dominant view among US legal scholars seems to be that judges should defer to the interpretive methods of judges in the law supplying jurisdiction, regardless of the judge's own opinions on the merits of those methods. So this view might be driven by positivist assumptions that the scholars don't generally acknowledge. So I will end there. Thanks so much for listening. I'm going to stop sharing my slides so we can see one another better, and I'd love to hear any thoughts that you might have.
Thank you very much, Professor. I'm sure you will all join me in thanking Professor Nina Varsava for this very interesting presentation. We'll now stop recording since we will be moving on the Q&A